Hello. Am I audible? Am I visible? Just one second. Please do let me know, am I audible and am I visible? Hello, good evening. Good evening. So can you hear me and can you see me? Good evening Haripriya. So today I am going to discuss these two chapters. So yes, I'm going to discuss two chapters today, and so how are you guys doing? I know the pressure is building, and I know sometimes it can be a little too much to take also with the exams just round the corner. Right. Good evening, guys. Good evening. I hope you are coping fine. I am very sure my students are strong enough to be coping very fine. The only strong people can take up CA course, right? It's not a course for the weak hearted. So I'm pretty sure my students are going doing good only. But anyway, we'll do a quick recap of these two chapters today, and I just kept it in the same video only because after today I will not be online mostly. So that's the reason I kept it in the same video. So this is for 14 marks chapter, and question 5 and question 6 will have two questions from this chapter. That is 7 marks. It could be 7 marks, 7 marks, 7 marks, 4, 3 marks, like that. You will have two questions or three questions or four questions from this chapter. Mostly three questions. Okay? As I say, very, very easy chapter. It would be very, very stupid of you to not do this chapter. Okay, so basically what do I mean by a negotiable instrument? When I say negotiable, negotiable means transferable, instruments mean document. So any document which is what? Freely transferable. So when I say negotiable instrument, section 13 of the act defines the term negotiable instrument, which says it means a promissory note, a bill of exchange, or a check, right? It means a promissory note or a bill of exchange or a check payable to or to the order of or to the bearer of the instrument. So to or to the order of means it's a specified person, to the bearer means the holder of the instrument, right? Now, I'll do it with the material. Sorry, I'll just keep the material open. I'll just do it with the material only. Ah, so it means what? It means a promissory note, a bill of exchange, or a check payable to or to the order of or to the bearer of the instrument. When we say order, means it's payable to a specified person. Bearer means it is payable to the person who holds the instrument, right? Holder. That means when we say negotiable instrument, only a promissory note, a bill of exchange, or a check is a negotiable instrument. So what are the characteristics of a negotiable instrument? It has to be in writing, it must be signed, freely transferable. Freely transferable, does it mean without consideration? No. Free doesn't mean without consideration. Free means it's transferable. It is transferable. You cannot, it's always transferable from one person to another. Holder's title is free from all defects. That means if you are a Thank you so much for all the love from Mumbai. So if you are a holder in due course, then you get the instrument free from all defects. What it means is, who is a holder in due course? A person is said to be a holder in due course if he gets the instrument before maturity, if he gets the instrument in good faith, and if he gets the instrument for consideration. If all these three conditions are fulfilled, I can say he's a holder in due course and he gets the instrument free from all defects. That means what? It reaches the hands of a holder in due course. Before that, it was stolen or anything. It was without consideration, whatever, any defect. Those defects will go away from here. And here, the moment it reaches the hands of a holder in due course, the instrument is free, it's clean, and it's a valid instrument. And in fact, if he gives it to anyone, that person will also get a good title. Then there must be an unconditional promise or order to pay. So just acknowledging the debt is not a negotiable instrument. I have to make a promise that I'm going to pay this money, or I'm going to make an order to you to pay the money. Then all the things must be certain, as in the amount must be certain, the time when you will pay should be certain, the parties must be certain, and very important, it has to be delivered. Delivery or questions on delivery is also another very important aspect of this chapter. So you can actually get a lot of questions on delivery. Make sure you do all of them. So when I say delivered, delivery must be of the whole instrument and not a part of it, right? Delivery must be of the whole instrument and not a part of it. Chalo, moving forward, promissory note. What do I mean by a promissory note? Section 4 defines a promissory note as an instrument in writing. So oral nahi ho sakta. Not being a bank note or a currency note. Why do we say not being a bank note or a currency note? Because when you see a bank note or a currency note, it is written on it, I promise to pay the bearer. So that is not a promissory note. Okay? So because other than government, no one can issue a promissory note payable to bearer. So on that grounds, we cannot say a bank or a currency note is also not a promissory note. Containing an unconditional. So the promise must be unconditional. Undertaking. Undertaking means promise. Signed. So it has to be signed by the person who is making it. To pay a certain sum. So the money must be certain. And it should be to pay money only. To or to the order of a certain person. So the parties must be certain. Or to the bearer of the instrument. Now, whenever we write bearer of the instrument, always remember as per RBI, other than government, no one can issue a promissory note payable to bearer. So, when you write the definition, you cannot write this. You have to write payable to or to the order of or to the bearer of the instrument. Okay? We have two parties, maker and pay. Maker is the person who makes the instrument, who gives the promise, right? And the pay is the person to whom the promise is given, to whom the money is payable. What are the characteristics of a promissory note? It has to be in writing. So an oral promise is not a valid promissory note. There must be a promise to pay. That means what? If you just make a promissory note acknowledging yourself indebted to the other person, it is not a valid promissory note. It is not a valid promissory note. There has to be a promise to pay, right? The promise must be definite and unconditional. That means what? It should not be that I will pay you only when you give me the goods. No, you cannot. It cannot be conditional. It must be unconditional. Definite means certain sum of money. Then it must be signed by the maker. It must be money only. I will deliver you 100 kgs of rice and pay you 1000 rupees. No, 100 kgs of rice is not a promissory note. The sum of money should be certain. That means it should not be open to contingent additions or subtractions. So if I say after deducting all money you owe me, no. But if I say along with interest at the rate of 12%, that is valid. If I say along with interest at the rate of 12%, that is valid. Why? Because that is not a contingent addition. One more thing, when a condition is sure to happen, okay? When a condition is sure to happen, but we don't know the time of happening, but it will happen, like someone dies. This is a valid promissory note because everyone is going to die. No one is immortal here, right? And the parties must be certain, definite, and different persons. That means I cannot draw a promissory note. I promise to pay Nitika rupees 1000, signed by Nitika. Who is Nitika? Maker. Who is Nitika? Pay. Both the Nitikas are same Nitika. Is it a valid promissory note? No. Ma'am, if you make a promise to pay some other Nitika, Are Baba Re, that is okay. I'm talking about me, same. I'm promising to pay myself. And there must be some presumptions are there. It should be properly stamped. It is always made for consideration and all. A bill of exchange. A bill of exchange is an instrument in writing, again, containing an again unconditional order signed. So it has to be in writing, it has to be signed, directing a certain person to pay a certain sum of money and money only to or to the order of or to the bearer of the instrument. A has to pay B rupees 10,000. A writes, I promise to pay B. This is what? Guys, tell me, this is what? Is it a bill of exchange or a promissory note? Is it a bill of exchange or a promissory note? Hello, hello. I promise to pay. It is what? It is bill of exchange or is it a promissory note? It is a promissory note. But if it is written, it's a promissory note. Mr. B, Mr. A, I order you to pay me a sum of 10,000. Yes. Signed by, I order you to pay me a sum of 10,000, signed by B. Then it is what? Then it is what? I order you to pay me a sum of rupees 10,000. Mr. A, I order you. So please remember, in promissory note, the debtor makes the promissory note. But in bill of exchange, the creditor makes the promissory note. Bill of exchange. I'm so sorry. Instead of pay me, if it was written pay C. So here's pay is C. That means I'm ordering you to pay C. So here pay is different. And if I say pay me, pay and drawer is the same. Drawer is the person who makes the instrument. Drawer is the person on whom it is made. Pay is the person who is named in the instrument as to whom the money is to be paid. Right? What are the characteristics? If you see same characteristics, right? Same characteristics. It is the same. Please add one more thing here. As per RBI, no one can draw a promissory note payable to bearer. Okay? As per RBI, no one other than government can issue promissory note payable to bearer. Now moving to check. Or do I need? Please do read the differences. They do ask you questions on differences. What is a check? A check is a bill of exchange. So it's a bill of exchange. So we have three parties here also. Drawn on a specified banker. Always remember, in a check, the drawee is always a banker and not expressed to be payable otherwise than on demand. That means what? It is always payable on demand and includes an electronic image or a check in a truncated form. That means it's instead of a paper check, electronic check, and check in a truncated form is a check which is converted into the electronic image at the time of clearing by the clearing houses. So here is the name of the bank. This is the drawee bank. Here pay this person. So let us say I write your name here. You become the pay. And obviously I'm going to sign here Nitika. So this is the drawer, right? Now parties to the check we have already discussed. Same thing. Two characteristics of a check which distinguishes a check from. Now they will give you a question. What are the characteristics of a check which distinguishes a check from a bill of exchange? You will write differences. No, they are not asking you differences. They are just asking you the two specific characteristics. First, the drawee is always a banker, and second, it is always payable on demand. That's it. Right? Now, types of instrument. The next one, types of instrument. What is types of instrument? First, bearer, second, order. Bearer means it is payable to the holder. Order means it is payable to a specified person. Just 1 second, guys. So, bearer means holder, order means specified person. So when I say bearer means holder, that means it is drawn originally as a bearer instrument, or the last or only endorsement was in blank. That means when the endorsee signs, where the last endorsement is in blank, that means endorser signs but no name of endorsee. So it becomes what? It again becomes a bearer instrument. Order instrument is when it is payable to a specified person or as per the order of the specified person, or the last endorsement is in full. When I say endorsement is in full, that means endorser signs and also name of endorsee is given, right? Inland or foreign instrument. What is inland instrument? Has to be drawn or made in India. This has to be there, drawn in India, and out of this to anyone, made payable in India or drawn on a person resident in India. Right, on a person resident in India. So this is mandatory, and out of this anyone. So it becomes what? It becomes an inland instrument. What is a foreign instrument? Obviously, which is not an inland instrument. So it is drawn outside India, or it is drawn in India but payable outside India on a person resident outside India. Whatever. Any combinations. The next one, inchoate or ambiguous instrument. What is inchoate instrument? It is an instrument which is incomplete in some sense. Right? It is an instrument which is incomplete. That means signature is there, but the other information, sign is there, but the other information is incomplete, either wholly incomplete or partly incomplete. So I am giving an authority to the other person to fill up the instrument, but I am liable to the other person only to the authority given. There is a question, and many of you have asked me this doubt, so please pay attention. A gave an inchoate instrument to B and asked him to fill for 15,000. The total value of the instrument is, let's say, 20,000. Right? B fills it for 20,000. How much can B recover from A? Guys, I want everyone to answer how much can he recover from A. Because the authority was given only for 15,000, how much can he recover from A? Only 15,000. How much can he recover? Only 15,000. So even if he fills for 20,000, he can recover it only for 15,000. Now B gives it to C, who is C, a holder in due course. This is another situation. That was one situation. This is another situation. What is the other situation? B gives it to C, who is a holder in due course for 20,000. Okay. So I have two questions. You will answer accordingly respectively. How much C can recover from A and from B? Tell me. From A, from B. Okay. Okay. So see here. So see, where one person signs and delivers to another person a paper stamped in accordance with the law, and he thereby gives prima facie authority to the holder to make or complete, as the case may be, upon it a negotiable. The person so signing shall be liable upon such instrument in the capacity in which he has signed, that is 15,000, to any holder in due course for such amount. That means to the holder in due course he is liable only for what? 15,000. Provided that no person other than a holder in due course shall recover from the person delivering the instrument anything in excess. So from B, how much can he recover? So from A he can recover only 15,000 because that's the authority, but from B he can recover how much? 20,000. Yes, I hope it's clear to all of you. Yes, moving forward to the next one, ambiguous. Ambiguous means not clear. When an instrument looks like both a promissory note and a bill of exchange, I name it as a bill of exchange and I write, I promise to pay. So this looks like both a promissory note and a bill of exchange, right? So this is what? This is a ambiguous instrument. The holder may decide to treat it as what? The holder may decide to treat it as a promissory note, or the holder may decide to treat it as a bill of exchange. Whatever the holder decides, from that day onwards, that instrument will be treated as such. Moving forward to the next part, endorsement, negotiation. Negotiation can be done either by delivery or by endorsement and delivery. When the instrument is payable to bearer, I can just hand it over to another person and make him the owner of the instrument. So it can be done by delivery. But if the instrument is payable to a specified person, if the instrument is payable to a specified person, then I have to write his name on the instrument and deliver it to him. Then it is that, then the negotiation is complete. This is known as endorsement and delivery. Endorsement means to write something on the instrument so as to, and to deliver it to the other person. Now here I told you the point of delivery is very, very important. Correct? Endorsement is never complete unless delivery. Delivery of an instrument is essential whether the instrument is payable to bearer or to order to affect the negotiation. The delivery must be what? Voluntary, and should be to, the objective should be to pass the property to the person to whom it is delivered. The delivery can be actual or constructive. There is no symbolic delivery here. Okay. Then fourth one. Fourth one, you don't have to write in normal cases. If let's say A has endorsed it to be with the condition that the money is payable only when you receive the goods. Money is payable only when I receive the goods. B endorses it to C, who's a holder in due course. B can recover the money only when the event happens. But if I give it to C, who's a holder in due course, he can recover the money on maturity irrespective of whether the condition happens or not. So see, where an instrument is conditionally or for a special purpose only delivered, the property does not pass to the transferee even if it is endorsed to him unless it is negotiated. That means the transferee will not become the owner, but if the transferee is a holder in due course, he becomes the owner and has a right to recover the money. Then delivery is essential not only at the time of negotiation but also at the time of making the instrument. Okay? The rights of the instrument does not transfer to the endorsee unless the instrument has been delivered. And the last one, if a person makes the endorsement but before the same could be delivered, the endorser dies, the legal representatives cannot negotiate by delivery. That means they cannot complete the negotiation just by delivering the instrument. Guys, any point you want me to explain? So I repeat again, when I say delivery, the instrument endorsement is complete only when it is delivered. Delivery must be made at the time of negotiation by delivery, or at the time of negotiation by endorsement or delivery. Delivery can be actual or constructive. Then again, delivery is considered as valid, endorsement is valid only when it is completed by delivery. On the death of the person, delivery cannot be completed by his legal heirs. So it has to be only if someone as the agent can deliver the instrument only when he has been authorized by the endorser. Anything you want me to explain again? These are important aspects when it comes to negotiable. Then the next one, dishonor of check due to insufficiency of funds. This only covers dishonor. Why? Because of insufficiency of funds. I'm not talking about anything else. Punishment is twice the amount of the check, or twice the amount of the check, or 2 years, or both. But generally it's or no. So we'll not actually punish the person. Generally we take a fine out of court. So see here, when a check has been issued for the discharge of a debt, and the amount of money standing to the credit of that account is not sufficient, or it exceeds the amount arranged to be paid, that is, it does not, the amount exceeds the amount to be paid, then such person shall be deemed to have committed an offense. If you cannot remember all of this, just remember, when a person has issued a check for the discharge of a debt, and the amount in his bank is not sufficient to pay the check, then in such a case he shall be punishable by. Okay? But the following conditions have to be fulfilled. Should be presented within a validity period, right? It should be for the discharge of any debt. So any check given as a gift or donation shall not come here. So it should be presented within the validity period. So what is the validity period? 3 months, or the period of validity of the check, whichever is earlier. Then it must be to discharge a lawful debt. It must be to discharge a lawful debt. So I am making the payment to discharge a debt. Okay? Then when the bank informs me that your check has been dishonored, the bank will inform the payee. Okay? Payee shall within 30 days inform the drawer that your check has been dishonored. Now the drawer is given 15 days. If within 15 days he pays, no problem. If within 15 days he does not pay, then he will be punishable. Right? Then he will be punishable. I hope it is clear to everyone. Yes? I hope it is clear to everyone. This question is important. They do ask this question. Now, if the contract, say in the question it doesn't say whether the check was issued for a debt or not. Ma'am, they did not say anything. Ma'am, so I assumed it is issued for no consideration. Hey, wait, you cannot. If nothing is given, it is assumed that it is for a lawful debt. Right? If a check is dishonored, it shall be presumed, unless the contrary is proved, that the holder received the check for discharge of any debt. That means assumed the check is paid for. Check is given for payment of a debt. That will be assumed. Right? It will be assumed. So I repeat again, if nothing is given, we assume it was given for a lawful debt. If something is given, that it was given for a donation, gift, whatever, then it's different. Otherwise, we assume that it was given for the payment of a lawful debt. I hope it is clear to everyone. Okay? Can I go forward? Anyone has any doubt? Before we go forward, if anyone has any doubt in this, first tell me, then we will go forward. Wow, everyone has stopped also, messaging also. Gone in some other zone only, huh? Chalo. Presentment of instruments. See, we have presentment for three things. Presentment for acceptance. Okay? So, presentment for acceptance is when the bill of exchange is payable after sight. We have to present it for acceptance. Then next is presentment for sight. Wow, what am I writing? For sight. This is promissory note which is payable after sight. For this we present. And the third one is presentment for payment. This is for all the instrument, because on due date every instrument has to be presented. Okay? A bill of exchange after sight, payable after sight, must be presented, right? Where? If a place is given, at that place. If no time or place is given, wherever that person can be found. So, it shall be presented by a person entitled to demand acceptance. That means the, what do you say, the drawee or the holder, anyone. The drawee or the holder. So, who can present it? Who can present it? The person who is entitled to demand the payment. Place, where? No time or place is given, wherever he can be found after reasonable search. So see here, time, it should be presented within a reasonable time. Day, on a business day. Place, if any particular place is given, at that place. And if no place is given, wherever he can be found after search. And how will you present it? Through post office by means of a registered letter, right? If the person cannot be found after due search, if a place is given, I should present him at that place. And if after due search that person cannot be found, the instrument is dishonored by non-acceptance, right? The instrument is dishonored by non-acceptance. You are given 48 hours to accept. If you take more than 48 hours, again, the instrument is dishonored by non-acceptance. Okay? If a promissory note is payable after sight, you have to present the instrument for sight. Because only when you present, the maturity from that period will start. So to determine the maturity period, I have to present the instrument. Correct? So payable for sight must be presented for sight by whom? By a person who is entitled to demand the payment. If a place is given, at that place, and if no place is given, wherever he can be found after reasonable search. Within a reasonable time, during the business hours, on a business day. So if you see here, it is the same as this, right? So who can present the instrument? By the person who is entitled to demand the payment, correct? Where can you demand, where can you ask him to present? Wherever he can be found after search. Time, within a kya? reasonable time. Time within a reasonable time. Then day and time. On a business day during the business hours. If default is made in presentment, no party will be liable. If you have made a default in presenting the instrument, no one is liable. So, if default is made, no one is liable. So, please remember, this is presentment of bill of exchange for acceptance. Who can present it? The person who has a right to demand acceptance. It can be presented at a place specified, and if no place is specified, wherever he is found within a reasonable time or during the business hours on a business day. And how will you present it? By the post office by means of a registered letter. And in case of presentment promissory note for sight, it should be presented by a person who is entitled to demand payment within the reasonable time on a business day during the business hours. And if default is made, no one is liable. Okay? If default is made in such presentment, no party is liable. I hope it's clear to all of you. Presentment for payment, this is for all the instruments. See here, whether it is whether it's a promissory note, a bill of exchange and a check, all of them have to be presented to the maker. Promissory note presented to the maker for payment, and then bill of exchange presented to the drawee for payment, and check will be presented to the bank or the drawee banker for payment. Right? If default is made in presentment, no parties are liable. That means on due date you don't present it, and then you're like, you did not pay, you did not. What? I did not pay, you never presented it, right? Now, how will it be presented? Through the post office by means of a registered letter. They've asked questions on this sometimes. When the note is payable on demand, that means there is no maturity period, it is payable on demand. Okay? Then it is not payable at a specified place. First, it is payable on demand. Second, not payable at a specified place. Then presentment is not necessary. This is only for a promissory note when presentment is not necessary. That is, you don't have to present for payment. That means the person does not have to present to get the money. When it is not payable at a specified place and it is payable on demand. I hope it's clear to everyone. If payment is made on a truncated check or or an electronic image of a check, and the banker has a doubt, the banker can ask the other person to give the check, and after that they can retain the copy of the check for future evidences. Okay? Now, this is presentment for payment we are discussing. This is for payment. Okay? It should be during the usual hours of business. And if it is a bank, banking hours. When? At maturity. That is on the due date. Not before, not after. If it is payable in installment, third day after the date fixed for payment of each installment. On every 15th we have to pay. It should be presented on every 18th. 3 days from the date fixed. If it is payable at a specified place, it must be presented at that place only. If no place is given, then at the place of business or his residence. If we don't have any place of business or residence known to us, wherever he can be found. Right? In case of check, presented at the bank upon which it is drawn. That means the drawee banker. That means if I have an account with HDFC and I give you a check for payment, you will present it where? At HDFC. Okay? Within what time? Within a reasonable time after delivery. If it is payable on demand, obviously it should be presented because there is no maturity, within a reasonable time. If the presentment is made by an agent or to an agent, may be made to the agent. Okay? Or when the drawee has died, to his legal representative. So we can make the presentment to the agent or to the legal representative if the person is dead, or to his assignees in case he has become insolvent. Let's say the person was going for getting the payment While going, he met with an accident, went into coma. Will this period be excused? Yes. So, if the delay is caused by circumstances beyond the control of the holder and not something that is his default, misconduct or negligence, then it can be excused. Excuse means ignored, not taken. Okay? Cases where presentment is not necessary. If the person prevents the presentment intentionally, knowingly, you are avoiding the presentment, right? If it is payable at a place of business and that place of business is closed during the business hours, I go to the office at 11 in the morning, it's closed. What can I do? If it was presented at some other specified place and I go there, but that person does not come or his authorized person does not come, he asks me, come to the CCD, come to the Starbucks, CCD, whatever. I go there, sitting, coffee pe coffee, coffee pe coffee. Paisa to mila nahi, I spent more money on the coffee also, gone. If the instrument is not payable at any place, he cannot be found after search. Presentment is not necessary. Second, he says, irrespective of you present or not, I will pay. That means the person says, I will pay even if you don't present. That means the person says that even if you don't make any presentment, I will still pay your money. If after the maturity, the other person knows that the instrument was not presented, but still he makes a part payment. The moment he makes a part payment, he is acknowledging that yes, I am liable. Now presentment is not necessary. Or he makes a promise that I will pay, right? Or he waives off his right. He says it's okay, you did not give a notice, doesn't matter, I will still pay you. He gives up. Waives means gives up. That means what? On maturity, knowing that he did not get a notice, still he makes a part payment or he promises to pay later, or he waives off his right. He says, no problem, even if you don't present, I will still pay. Then presentment is not necessary. And the last one, if you don't present also, the other party will not suffer any damage. I hope it's clear to all of you. Rules as to compensation, you will claim the amount plus you will claim any expenses incurred, noting, protesting, whatever. Plus you will also get interest at the rate of 18%. From which date? From the day you were supposed to pay till the date that you finally pay. With this, we are done with negotiable instruments. Guys, anyone wants to ask me anything? Otherwise, we will move to the next part. Okay, chalo, we'll move to the first chapter. Like they can ask you questions on delivery wala portion, endorsement and delivery wala portion. They can ask you 7 marks ka question on dishonor of check. They can give you, two types of questions on that, right? They can give you two types of questions on that. So these are the types of questions they can ask you for 7 marks. They can give you questions like what is considered as, in all of this, what is considered as, what you say, what was that? Array, see how, why did I forget? What they can give you few cases and say whether it's a valid promissory note or a bill of exchange, whatever, right? So moving on to Indian regulatory framework, I have a PPT, but it's not complete actually. IRF from it's not complete. It's a scanner. Just 1 second, guys. Huh? So because this has questions also. So Indian regulatory framework, why you should study this chapter? First, it is a 6 marks chapter. Second, it comes with questions from Indian Contract Act, and also you have already done those chapters, and if you skip this for no reason, you will have to skip that chapter, that question. So that's the reason you should do it. What all you will cover here: what is law, sources of law, process of making law, types and enforcing of law, major regulatory bodies, and the structure of Indian judiciary system. These are the actually 6 topics that you have to study here. And honestly speaking, guys, this chapter is super easy, right? So what basically is this, what you say, Indian regulatory framework? I know it's very, it's very, the chapter is like, oh my god, why do I need to do this? But still, it's actually a very easy chapter, 6 marks, why to lose it? Why do you need to study this? Because see, you are going to become future CAs, okay? You are going to become future CA, and as a CA you will have to come across contracts at many levels. You have to come across legal matters. So if you don't know about these, legal matters at the basic level, it will be very difficult for you to identify, to guide your clients. So to help you to guide your clients, they are necessary. What is the purpose of this? They provide a set of uniform law and regulations. This Indian regulatory framework, they actually give us a uniform system of law and regulations, uniform rules and regulations, which help us. They act as a guideline. They govern the conduct of the people, how the people are supposed to act, how they should act. It gives us that. Otherwise, how will the judiciary system, how will the whole country also work without them? And law is not something here and now. We have had laws even earlier. In fact, the first one was the Code of Hammurabi, which is the oldest written law, right? And in 450 BC, we had this, what you say, 12 bronze plates. Sorry, if you remember, I had showed it to you in the class also when I was teaching you. The 12 bronze plates are there, which were actually the first ever written law in 450 BC. Coming back, the Government of India Act 1935, this was actually passed by the Parliament of UK. They defined the Indian system as a federal system. What is this federal system? Federal system means the power was distributed between the central government and the state government. The power was distributed between the two, between the central and the state government, right? Now in 1937, the federal court was established. What was established? The federal court was established, which is today's Supreme Court, and it had the jurisdiction of appellate, original, and advisory. That means they could take the original cases, they could take appeals from the cases from the lower court, and they used to advise the Governor General in power of public, in matters of public opinion. That means they used to guide and give their opinions to the Governor General to help them make the laws and everything. The federal court operated for approximately 12 years and had heard 151 cases, which was later supplanted by India's apex court, which is Supreme Court of India. Constitution of India 1950 is the foremost law which deals with the framework. So what are the sources of law? What is law? Law is a set of rules and obligations imposed by the government for securing welfare and providing justice to the society. This is the motive of law. What is law? It is a set of duties and obligations which are given to us by the government so that we can secure the welfare and give justice to the society. So, what are the sources of law? Obviously, the first and foremost is the Constitution of India. If you remember, Constitution of India 1950, right? They tell they that is the major source of law, guides us on how the laws have to be made, right? And the Government of India Act 1935 declared that India is a what? It is not a unitary system, it is a federal system. Then the second is the laws which are made by the parliament or the state assemblies. If you remember, it's a federal system. How do I know it's a federal system? Because of the list 1, list 2 and list 3 which is given in the constitution. List 1 is laws which are made by the parliament, that is the union list. List 2, which is the laws made by the state, that is the state assemblies. List 3 is concurrent list where they both have the power to make the laws. Precedents or the judicial decisions of the various courts. So sometimes it happens that we don't have a judgment, but the Supreme Court gives a judgment, right? It gives a judgment. So when the Supreme Court gives any judgment, it is binding on everyone. So precedent means it's a judgment given by the court. For example, if you remember in partnership, you do the concept of Garner versus Murray. So that concept of Garner versus Murray is not given by the act. It is actually laid down in the case of Garner versus Murray of settlement of accounts in insolvency. So that's a precedent. The Supreme Court ka judgment is binding on all the other courts. And the last one is custom and usage. We are in India. Custom plays a very, very important role in our country. Right? Custom plays a very, very important role in our country. And custom also become the laws. Then the next one is Constitution of India has divided the law making power between the central and the state government. We already know that. Just discuss this list wala thing. We've already just discussed this, right? Now, so can you get a question here? Yes, you can. What are the different sources of law? Explain them. So here you will write about Constitution of India, statutes passed by the Parliament or the state assemblies, judicial precedents and customs. Now, how is law made? First, a bill is introduced. Then it is passed in the Lok Sabha. Then it is passed in the Rajya Sabha. Then the president signs it. It's notified in the official gazette. And once it's notified in the official gazette, it becomes applicable. That is the effective date of the law. Now, what are the different types of law that we have? Criminal law, civil law, common law, and principles of natural justice. Criminal law. It is a law. It is basically a wrong which is done against the public. And the motive is not to get remedy. The motive is to punish the wrongdoer. Right? So it is a law pertaining to violation of the rule of law or public wrong and punishment of the same. Right? Guys, please, these words have to be there. And punishment of the same. It is governed by Indian Penal Code and Criminal Procedure Code. Indian Penal Code is a substantive law which defines what is a crime and what is the punishment for the same. And Criminal Procedure Code is a procedural law which tells us how to file the case in case of any crime. Indian Penal Code, please, in the book the old name is given, but when you write it, please do write the new name, which is Bharatiya Nyaya Sanhita and Bharatiya Nyagrik Suraksha Sanhita. Indian Penal Code is Bharatiya Nyaya Sanhita and Criminal Procedure Code is Bharatiya Nagrik Suraksha Sanhita. Whenever you are writing, make sure you write the new name along with the old name. Okay? Civil law, it's a wrong against the person. Now, if you get a question on civil law, make sure your answer has these words. The civil law focuses on dispute resolution rather than punishment. It is the motive is basically to compensate the aggrieved party. When you write the answer, make sure dispute resolution is there in your answer. It's basically enforces the violation of certain rights and obligations. The act of process, how you will file the case and everything, is governed by the code of civil procedure. You can classify it as the law of contract, the law of torts, family law, property law, and breach of contract, or family disputes, or what you say, damages, disputes between landlord and tenant. They are all examples of civil law. What is common law? Common law is basically a judicial precedent or a case law, right? It's a judgment. Now see, any judgment, basically it is, the concept is uh, doctrine of stare decisis. What is stare decisis? To stand on all four legs. That means to stand by what is decided. When a court has already decided something, you should stand by it. And it's given under article 141. Okay, it's given under article 141 that the judgment, please try to remember if you can, that the judgment of Supreme Court is binding on all the lower courts, right? The judgment of Supreme Court is binding on all the lower courts. The last one, principle of natural justice, it works on two guidelines. What are the two guidelines? Nemo judex in qua sua, no one can be made a judge of his own case. Three guidelines actually. Or the altrum partem, that means the other party should be given an opportunity of being heard, and the decision should be a reason. That means whatever decision you have come upon, it should be there should be a proper reasoning behind that decision. Now, a judgment can override or alter a common law, but it cannot override the statute. That means what? When a judgment, that is a judicial precedent, okay, can it go against the common law? Can it go against the common law? Common law means another judicial judgment. Yes. Yes. But can it go against the law? Against the statute, law passed by the parliament? No. It can never go against the laws passed by the parliament. Okay. So what are the different types of laws in India? Explain them. So this is a question where you will talk about criminal law, civil law, or you say common law, and principles of natural justice. You cannot just give the heading. 6 marks, you're supposed to explain it properly. Okay? How is law enforced? So basically, the government will have executive authorities. These executive authorities, they actually execute the law. So this is done through ministries of the government. The ministers will oversee, and these ministers are aided by the civil servants. They manage the daily operations of the ministries. The civil servants, so they have different ministries, that like MCA, Ministry of Finance. You have different ministries, and these ministries are run by these civil servants, right? This notes is only up to this point. So now about the ministries, we will continue here. They can even ask you, give a short note on any of the three ministries. It's a ministry of within the government of India. Basically, it is concerned with, these words should be there: economy of India, serving as the treasury of India. It concerns itself with taxation, financial laws, financial institutions, capital markets, center and state finances, and union budget. Please try to remember them. So I repeat again, what is the work of the Ministry of Finance? First of all, it is concerned with the economy of India and serves as the treasury of India. It concerns itself with taxation, financial laws, financial institutions, capital markets, center and state finance, and union budget, right? It is the head of 4 central civil services. What are those 4 central civil services? Indian Revenue System, Indian Audit and Account Service, Indian Economic Service, and Indian Civil Accounts Service. These are the 4 bodies which are headed, which the apex or the head is what? Ministry of Finance. The main important function of Ministry of Finance is what? Union budget. Right? What are the different departments that we have in the, please, when they are asking you questions, whatever is the question relating to that, please give your answer. What are the departments? You have Department of Economic Affairs, Department of Expenditures, Department, see, it is related with finance. So expenditure, income will all come here, right? So Department of Economic Affairs, because it's related with economic. economy of the country. Then it is related with finance, so Department of Expenditure, Department of Revenue, right? Then it is related with financial market, so Department of Financial Services, Department of Investment and Public Asset Management, and Department of Public Enterprises, right? Ministry of Corporate Affairs, our ministry, right? Law का सबसे important ministry is this only. So it is a ministry, Indian government ministry. These words have to be there. It governs which law? Companies Act, whether it is 2013, whether it is 1956, LLP Act, and Insolvency and Bankruptcy Code. No problem to remember, only no. We are studying this, and we have heard ma'am refer to this so many times. So it governs Companies Act, LLP Act, and Insolvency and Bankruptcy Code. It manages the industrial and service sector because it is managing the industry, MCA, corporate means industry. So it is concerned with the regulation of Indian enterprises in the industrial and service sector. Obviously, the ministries are run by civil servants of ICLS cadre. That means this is their posting. So they must hold this post and they will be running this ministry. Okay? They are elected by the UPSC exams, civil service examinations, which is conducted by the UPSC. And the highest post here is Director General of Corporate Affairs. This is the top. He is the apex of ICLS cadre. The topmost, he is the person who is appointed. Ministry of Home Affairs. Home Affairs, it is the ministry again of Government of India. Please understand Home Affairs. So it is supposed to take care of the home. So basically, like Ministry of Finance is in your home, you will see some people go out to earn money, right? They are Ministry of Corporate Affairs, Ministry of Finance. Home is what? Mom. Everything has to be taken care by her, generally mom, right? Whoever is taking care of the house, irrespective. So they will have to take care of the internal structure of the house, security of the house, correct or not? They will have to take care of all the members. So they are ministry, as an interior ministry of India, it is responsible for maintenance of internal security and domestic policy. And let me tell you, mom ka rules, even dad cannot go against it. Whatever home rules, home minister is mom, right? So home minister is headed by Union Minister of Home Affairs. So if you see the department, kya hai? Department of Border Management, outside, internal security, Department of Jammu and Kashmir and Ladakh Affairs, Department of Home, official language. What language you speak at home also is decided by mom only. Of Home Language and Department of States. Okay? Har ek room states. Again, official language can be classified into Central Translation Bureau, Central Hindi Training Institute, and Directorate of Census Operations. Department of Legislative Department and Department of Justice. Department of Legal Affairs, the Legislative Department and Department of Justice. Now see here, Department of Legal Affairs will manage the legal affairs. Legislative Department takes care of the legislative activities. And the Department of Justice, administration of justice in India. That means they manages that is the courts and all. They administer the what? So Department of Legal Affairs, they advise the various ministries of the government about drafting of the laws. So whenever the government is drafting the laws, they help in drafting the laws. Now these are the bodies. These are regulatory bodies. These were ministries. We have three ministries. Ministry of Finance, four. Ministry of Corporate Affairs, Ministry of Home Affairs, and Ministry of Law and Justice. Now it is bodies. So the first body is SEBI. It is a regulatory body, right? It passes regulations. And obviously it relates to financial market, and financial market is governed by Ministry of Finance. So it is under the Ministry of Finance. So it is a regulatory body for securities and commodities in the India market in India. Please cut this. This is wrong. Okay? It is under the ownership of Ministry of Finance, and it was established on 12th April 1988 as an executive body and was given powers on 30th Jan 1992 through SEBI Act. RBI It is a central bank and again a regulatory body. Again, RBI has to do with finance. So it is under the ownership of Ministry of Finance, Government of India. One of the main function of this is to control, issue and maintain supply of Indian rupee. This is the main function, and works to promote the economic development. So Bharatiya Reserve Note Mudra, Bank Note Mudra, you have to remember this, is the specialized division through which they print and mint Indian currency notes, and it is located in Nashik and Devas. You have to remember this, guys. Then they established National Payment Corporation of India, where they regulate the payment and settlement in India. So banks ka settlement, if you are making an online payment, that settlement, all of it is done by National Payment Corporation of India. Deposit Insurance and Credit Guarantee Corporation was established by RBI for the purpose of insurance of deposits and guaranteeing of credit facilities to all Indians. So this is a facility which is given to the other Indian banks. So when they give loans, when they give credit, so this is kind of a security which RBI gives to the other banks. Okay? Insolvency and Bankruptcy Board of India. This is under the Insolvency and Bankruptcy Code. Okay? It is a regulator for overseeing insolvency proceedings. So if any insolvency case is filed in the court, who will check, who will look after that? IBBI. And entities like insolvency professional agencies, insolvency professionals and information utilities in India. Basically, when you will do IBC, there are different bodies or entities who take care, who work in the process of declaring a person as an insolvent, right? They who file the cases, who take care of everything, not file the cases, sorry, who take care of the whole process. These are the people, and they are regulated by IBBI. It was established on 1st October 2016 and was given power through the IBC, which was passed on 5th May 2016. Now, when I say IBC code, it covers individuals, partnership firms, LLPs and body corporates. All are covered here. So see here, companies, sorry. It covers individuals, companies, LLP and partnership firm. All. So if you want to actually be declared insolvent, whether any of you fall under any of this head, you can go to IBC. And it is a new code which speeds up the process for declaring a person as an insolvent. It simplifies the process of insolvency and it has two tribunals through which the cases are filed. NCLT and Debt Recovery Tribunal, DRT, Debt Recovery Tribunal. Okay? Now, structure of Indian judicial system. This can concern dispute between you and me, dispute between me and the state of Karnataka, state of Assam or whatever. Three functions of judiciary. First, they interpret the act and laws. Whatever laws has been written, it is the work of the judge to interpret the law. Second, they settle dispute resolution. And third, they promote fairness amongst the citizens. That means in the eyes of law, everyone is equal. So they promote that fairness in the eyes of law. They promote the fairness that everyone is equal. At the apex is Supreme Court of India, which was established on 26 Jan 1950. The Chief Justice of India is the highest authority appointed under Article 126. So, Chief Justice is appointed under Article 126. Okay? The principal bench, earlier it was seven members, today it is 34, including the Chief Justice. That means today we have 34 judges in the Supreme Court. Now, if your fundamental rights are taken away, under Article 32, you can directly go to the Supreme Court for filing a petition. So, our Constitution ka Article 32 says that if a person's fundamental rights are hampered, he can directly go to the Supreme Court and file a case. The decision of Supreme Court is binding on all High Court given under Article 141. Binding on all the High Courts, right? High Court is the highest court of appeal in a state. In every state, the High Court is the highest body. The oldest one was in Calcutta. It is the highest court of appeal in each state and union territory. Article 214 says that there should be a high court in each state, but the six sisters, they enjoy one high court. So that is why there are 25 high courts in India. The six states share a single high court. Then the high court shall have appellate, original and supervisory jurisdiction. They can hear appeals, they can take original cases. And under Article 227, they also have the power to supervise the lower courts. Right? Now, an individual under Article 32, if my fundamental rights are taken away, I can go to the Supreme Court directly. Under Article 226, if my fundamental rights are violated, then under Article 32, I can directly go to the Supreme Court. Article 226 says you can directly go to the High Court also. So it's my choice whether I want to go and file a writ petition in the Supreme Court or I want to file it in the High Court. Article 32 allows me to go to the High Court. Article 32 allows me to go to the Supreme Court. Article 226 allows me to go to the High Court. Please remember all these article numbers. District Court, it is below the High Court. We have two here. The first one is the Court of District Judge and the second one is the Court of Sessions. They deal with civil matters, they deal with criminal matters. Right? Under pecuniary jurisdiction, pecuniary means what? Monetary. A civil judge, that means the Court of District Judge, can only take up cases of not more than 2 crores. That means if I am filing a case for a property, if the property value is more than 2 crores, the civil court cannot take the case. Cases are jurisdiction. How do you decide the jurisdiction? Jurisdiction is decided based on the local limits within which the parties reside or the property is situated. We reside in Bangalore, property is in Guwahati. So either the case can be filed in Guwahati or Bangalore. Metropolitan Court. They are established in metropolitan cities in consultation with High Court. So High Court will, with the consultation of High Court, we hire them. We establish them. If a city has a population of 10 lakhs or more, where the population is 10 lakhs or more. Here we have two. Chief Metropolitan Magistrate. He has the powers of Chief Judicial Magistrate. And then we have the second one, Metropolitan Magistrate. He has the power of Court of Magistrate of the first class. Okay? With this, we are finally done with this. You have any doubts or anything that you want to ask me? You have any doubts or anything else that you want to ask me? I guess no. So I will end this session here. Please study well. I don't know whether after this I'll not be coming online mostly. You anyway have a test Monday. Monday is what date? I don't even remember the dates now. Monday only, no? Oh, Tuesday you have test. What is the date? Don't even remember the dates. So anyway, study well guys. And if I do come online, I'll see you online. Otherwise, please study well. And any doubts, I'm available for the next 3-4 days. You can message me your doubts or anything. And I'll get back to you as soon as possible. Study well. Have faith in yourself. I don't remember what is the date today. That's the problem. I know 16th and 18th is your test. 16th is accounts, 18th is law. I know that. But I don't even know what is the date today. Anyway, so Excuse me. So anyway, Tuesday is 16 now. So you have your test on Tuesday. And now I think the next 2 days you should just spend studying accounts and not bother yourself about law. And obviously I'm there in case you feel the need. Today's 13th. Okay. In case you feel the need that you want me to come online for anything, just drop a message. We'll do that. Okay. Until then, take care, guys. All of you. All the best. Just have faith in yourself. You have put in so much of hard work, and you guys are too good, right? You are anyway too good, so don't bother yourself. I'll see you again very, very soon. So, all the best, and thank you so much, guys.